SJC-13352, Mark A. Adams v. Schneider Electric USA.
Okay, Attorney Mantell.
Thank you. May it please the court. Ilir Kavaya and I represent Mark Adams and are here to request a jury trial on his claim of age discrimination against Schneider Electric. In January 2017, Mr. Adams, who was part of the R&D department, was terminated as part of a reduction in force that affected only people aged 54 and over. We have strong and compelling evidence of age discrimination and ongoing corporate direction to get rid of older workers, many layers of pretext, strong prima facie case, statistical proof of age bias. In one very dramatic bit of testimony, while Mr. Colby alleged that he was not counseled on how to institute a RIF and no one suggested age, Michelle Gautreaux said that she met with him in connection with the RIF. She said, you can, information about age is going to be helpful for you to make a decision, and she literally gave him a spreadsheet.
Yeah, I found that kind of interesting, because that can also be trying to help avoid age discrimination, right? Having the benefit of that, she's not saying target the old people, she's saying you should know age discrimination. I mean, I don't even know if she says this. Age discrimination is out there. You should be conscious of who you're laying people off, right? I mean, we don't know what that means, do we?
Well, literally,
I mean, there are other things that may support your argument, but I found that one particularly weak, that she gives out. And is she required by law to do that? Is she required by law to do that?
no, she's not. No, she's not. At the time, they understood that they considered age diversity to be an important factor. And in their minds at that point, the desire for age diversity to them meant we need to get younger. And in fact, the case law on these anti-discrimination statutes say that your decisions should be age neutral. So the idea that you're giving out ages to people when you're making termination decisions shows you're not being age neutral.
I think that's a little tricky, but
Yeah, isn't the HR director supposed to actually, I guess, make sure that everyone's cognizant of age?
No, if anything, she should be saying age should be irrelevant to your decision. Do not look at people's ages. That's what.
But if you're not cognizant of age at all, then eventually you're going to be dealing with litigation, perhaps over pretext.
don't you have to worry about disparate impact too? You know?
Well, for example, if this were a race discrimination case and the HR director said, okay, lay off people, I'm going to give you important factors that would help you make your decision, and I'm going to give you the races of all the people under you, we would consider that as evidence that race was a factor in these decisions, and this is exactly the same.
Counsel, you're not asking for summary judgment. You're just asking to go to trial, right?
Correct.
Okay.
Correct. And
so any inferences, you know, we are in your favor, right?
That's correct.
Okay.
And along those lines, if we can just, tell me if I'm wrong, if we can just put this Reeves issue and this debate in the appeals court aside about what you do with unimpeached testimony of an employee. First of all, dealing with what that means in any case, never mind an age discrimination case with pretext and burdens, doesn't seem to make sense. But along the lines of what Justice Wedlin just asked you, you just have to show that there's a genuine issue of material fact as it relates to one pretext.
Exactly, and we have 7 or 8 instances of pretext here, including the Gautreaux.
So what Colby's unimpeached testimony means in all of this, and Reeves means really not what we need to focus on, is it?
That's true. You don't need to reach that issue. However, it's very, very helpful. In Bower, this court has said that the J&OV standard is the same as the summary judgment standard. And the J&OV standard says you disregard the evidence the opposing party, in this case, the employer.
You don't disregard the evidence. You look at whether there's a genuine issue of material fact from the evidence. You know, and say, well, I don't like that evidence, so I'll disregard it. But
Well-
I just don't think it's a big deal in this case, and more importantly, especially in a discrimination case with shifting burdens.
Well, for example, I think that's a valid point. And here we just need to prove one example of pretext. Now, Mr. Colby says I made the decision. But at the time of the termination, he tells Mr. Adams, I didn't make this decision at all. It was HR that made this decision. Then Mr. Colby says, I made this decision alone. But we know that's false because Mr. Sharma was there and he had authority and he literally vetoed one of Colby's decisions, and Mr. Sharma was identified as the person with authority in terms of the decisional unit.
The person he saved was how old?
Excuse me?
The person Mr. Sharma saved was how old?
66.
Interesting.
Well,
Interesting that you save the oldest person in the mix, right? This thing's a little, you know, it's a difficult employment case, right?
But that person was gone within months, and that person was experiencing
Is that in our record?
Yes.
That she's gone within months?
Yes.
Okay.
Yes. So,
How do we've got a couple of things here that are sort of unusual. You're reading back in time a lot. Your most compelling evidence that there is a sort of an ageist attitude out there is all based on things that, almost all of it's based on things that happened afterwards, right? Are there a number of cases that do that, look backwards, statements you made after the layoff to interpret how you were thinking during the layoff?
there's the Lynch versus Crawford case, which we've given you. But there's like 4 or 5 pieces of evidence that I'd like to go through that reference the time, the specific time. First, there's a statement in July 2017, which is 6 months after, which says, we have this ongoing strategy to get rid of older people in favor of younger people. And as an example of that, they refer to the Adams termination.
I thought that was the most interesting example, although, again, you're oversimplifying what they said. They didn't quite say we're dumping old people for young people. But I get your point that they can make the connection backwards and reference Adams in that.
There's a few other instances, if I may. In September 2016, they issue a policy statement saying, age demographics is an opportunity. This is just a few months before the
Can
termination.
I ask about that? Because that's the head of IT, right?
Yes.
Where does he fit in relation to, is R&D within IT, or is he just
Yes.
a totally separate manager, that person?
No, this is, so,
I remember his name. He's the head of the IT group, and I just didn't understand, is the R&D a part of the IT group, or is it a totally separate branch in that company?
it's ITD is below all of these. But this is in a document in which ARIA, HR lead, is emailing it to Gautreaux, who's also an HR director. And what they're saying is, age demographics is an opportunity. And
Hold on a second, but let's be specific. The thing you're referencing, from what I understand, begins with a statement from the head of IT saying something, and then she responds to that. But the ageist comment in that example comes from, does Colby in any way report up to this guy, or is this guy somebody in a totally different department and fitting in more within the stray comments kind of stuff that?
You are referring to a different document.
Okay.
Okay. Cermak, who is ARIA's superior, that's the initial discussion where they say, oh, we have to make room for younger workers. And then ARIA sends that off to Sharma and saying, let's talk about this, let's brainstorm about this. So Sharma is directly brought in. Colby is under Sharma. Colby testifies, it's my job to do what Mr. Sharma wants me to do. But going back to the September 2016 document, age demographics is an opportunity. Later, we learn in the records 711 to 713 that that's part of a strategy, meaning they need to make room for early career hires. How are they going to do that? They say, we're going to restructure and reorganize. Then they say, how are we going to do that? Then the next page is opportunities. Well, let's look at people who are performing poorly and people with long seniority. The older people are lumped in with people with poor performance. So in September 2016, when they say age demographics is an opportunity, that's what they're talking about. Then, after that, ARIA meets with Gautreaux and says, look, Colby is going to be doing this RIF. I am sending you to go counsel him on this RIF. And in the notes of that meeting, it says, deeper cuts for college grads. That's the instruction she was sent off to go speak to Colby about. Then when she meets with Colby, she says, consider age. Age is going to be helpful. Here's your data.
One thing, when I check your sites, I find that you're kind of filling in gaps here. Where is this point about deeper cuts for college grads and how, and that's directly connected? So when we go back and read these record sites, I just want to be careful with you. We're going to find that she says, right before she talks to Colby, she says, go tell Colby we want deeper cuts for college grads, or are you just connecting different pieces of paper that have nothing to do with each other? Because I want you to be careful here, because again, I actually tracked some of your things, and I didn't find they added up that directly.
These are written notes.
They're written notes for that ARIA is directing Gautreaux to tell Colby that, because that's kind of compelling stuff. Is that really going to show up? What page is that on in the record appendix?
July 6, 2017, I think, is what the conversation you're talking about.
So that's page 378.
To make room for new hires?
It says
And how does
deeper
that
cuts for college
How does
grad.
that connect to what she said to Colby? Is there something, I don't have this in front of me, on page 378 where Gautreaux, ARIA tells Gautreaux, tell Colby deeper cuts for college grads? Or are you just making connections between different documents and different things happening out there?
No. At this meeting, ARIA is telling Gautreaux, go coach Colby. Okay? They mention restructuring, and then there's a statement, deeper cuts for college grads. So reasonable inference is that is relevant to the coaching that Gautreaux is instructed to go off and do. So, and it dovetails with the fact that she actually goes to Colby and says, consider age. This is going to be helpful.
How does this fit into the big picture, at least from the appellee's point of view, that they say that your client unequivocally said that Colby didn't discriminate, and that the testimony is that, not these words, but he was an island. It was his decision and his decision only. He was an island, and that all of this other evidence and quote-unquote stray remarks are okay, but where's the genuine issue of material fact as to pretext when the plaintiff is admitting that that Colby didn't discriminate? Where do you get the genuine issue of material fact as to pretext in that context?
Okay. So the plaintiff never admitted that Colby never discriminated. What he did say is that he hadn't alleged it in a document. Okay. What the Schneider has done is they had a uncited title in their statement of facts, and to which there was no response required. And then they said that the plaintiff admitted to that title. And so there was no admission. Now, going to the island, there are many cases in which courts have rejected the assertion, including the Finney case, Flint versus Boston, and the Walton case, which is cited in our brief and Mila's brief. It's a question of fact, and the whole purpose of the McDonnell-Douglas standard is that the plaintiff is not an eyewitness to the subjective decision-making. So what McDonnell-Douglas says is, let's consider objective evidence that is viewed from the perspective of an outsider, the statistics, the comparator evidence, pretext, things like that. And what this Schneider is saying is, that's not relevant because we say it's not relevant based on our description of what happens in our secret meetings. And that the courts don't follow that. So I see my time is up, and without any extra questions, I'll rest on my briefs.
Okay, thank you.
Okay. Attorney Saloy, how do you say your name?
May it please the court, Dawn Reddy Soloway from
Sorry.
Cyfroth Shaw. I'm here with my colleague Chris Kelleher on behalf of the appellee Schneider Electric. Your Honors, we're asking that you affirm summary judgment for Schneider on all counts. I'd like to just remind the court that there's one count here for disparate treatment age discrimination. And so the question before the court is whether the plaintiff can get to a jury on the question of whether Colby selected Adams for the 2017 RIF because of his age. And on the undisputed facts, the unrebutted evidence that this court can and must consider under Rule 56.
I don't know, there's a lot of troublesome, corporate speak out there on this. And they've targeted this group for a pretty substantial cost savings. There's other groups they can pick, but they pick this group, and this group has got a lot of sort of elderly, or I don't know if it's the right word, given they're all younger than I am, but people in their 50s and 60s working there. And you've got these kind of age diversity comments. Isn't that enough to survive summary judgment, particularly when Mr. Colby has some inconsistencies too? He does meet with Goutreau. She talks about age. It's not clear why she's talking about age. It may be in a salutary way. It may be in an age diversity way. But there's a lot here. And then there's that document where they talk about age diversity and then they reference back to the plaintiff here. Isn't that enough to raise pretext?
Add to that, because it really stuck out with me that I think it's Granada wants to hire Adams. He doesn't want him to be laid off. They need him in the area of field quality. That seems to be a pretty important issue too.
Happy to address all of those issues, Your Honors. I think what's important here is that the business reasons for the layoff are unrebutted and undisputed. So we know that this business had been flat for 4 years. That's undisputed. And that they needed to have budget cuts of 22%. And so we also know, because it's undisputed.
There's another group of engineers in India, right? There's another group. Are they also, don't they have the same? This is one big company. It's not, we don't look at this as division by division.
So, Your Honor, India also was subject to budget cuts, but
much smaller, right?
But they were able to.
What was their percentage?
I don't recall their percentage,
It's like a single-digit percentage versus a 22%.
But, Your Honor, I would suggest to the court that the court is not to sit here as a super personnel department deciding whether.
I'm not here. I'm not.
No,
sitting
but we
as a
need to
super
apply the motion for summary judgment standard. And it seems to me what Justice Kafker and Justice Lawyer are suggesting is that there's enough going on here that they get to the jury. So why is that not the case?
Absolutely, Your Honor. So I think here it's undisputed that Colby is the person who made the selection. So he was given this instruction that they had to cut by 22%. He makes those
and he's
decisions.
also given the age demographics, and there's all this ambiance, not just straight remarks. but remarks by people in positions to make decisions, one of whom he reports to, Colby reports to, you know, enough here. I'm not saying Colby discriminated against the plaintiff because of age, but the point is you haven't shown that there isn't a genuine issue of material fact, given all of these things.
Your Honor, I think there's nothing in the record that suggests that this department was targeted because of age. There's just no evidence about that at all. So what we do know is that he was given
But
this...
again, what we look at is, we look at the whole picture, right?
Yes.
And we look at the fact, that how many people are laid off? Every single one of them is in their 50s.
Well, Your Honor, as the dissent pointed out below, that this group was old before the RIF and they were old after the
Well,
RIF.
but then the question is that why this group is getting a 22% cut when we're looking for, I mean, we're the head of HR and some high-level executives are talking about, we need age diversity. And can I ask one other little fact?
Yes.
This recruitment limitation, we're not going to recruit anyone over 58. Is that legal? Is there some legal basis for doing that? Because I've never heard of that before.
Your Honor, there is one citation in the plaintiff's brief to a reference in a deposition to that document. The document itself is not in the record. There's nothing developed about that document, but we do know is that document had nothing to do with RIFs or terminations.
Well, but if you're
and
not,
again, it's
but again,
Colby.
it's atmospherics. And again, I understand stray comments. You got some foreman out there making some stupid remark, we ignore it. But when we've got the head of HR and other significant players talking this way.
But, Your Honor, I would focus the court back on what's
And
undisputed.
by the way, again, that you're telling us we can't consider this issue about not hiring someone over 58? That's
nothing in the
not properly
record.
for us to consider? Well,
Well,
it's a statement, and this is a summary judgment, right?
So, Your Honor, what I'm saying is that there's nothing in the record about that document, about the context for that
deposition.
document. There's basically a single question about that document, and Aria said, I don't really recognize this document. That's all that's in the record. But we do know that the document on its face does not say anything about terminations or about RIFs.
But if we're not hiring elderly people, again, people younger than me, so we're not hiring people in their late 50s, that doesn't, and we want age diversity, and we're restructuring, and we list the plaintiff in a document about restructuring to make room for younger people.
Your Honor,
Again.
what I would say is that I think what the plaintiff is trying to do is to distract the court from the core undisputed facts of this case with these stray remarks that have nothing to do with the decision, nothing to do with Ken Colby, nothing to do with the relevant time period. And if we look at the undisputed record, Colby made these decisions by himself. That's
yeah, but
what
then
the record
he told
shows.
the plaintiff that it wasn't his decision to make.
No, Your Honor, he didn't.
He didn't.
If you look at the actual testimony, and I agree that the plaintiff has taken quite a few liberties with the record, if you look at that actual testimony, what Adam says is, I speculate that HR must have been involved because that's my perception of how companies work. He never said that anything about HR actually being involved. And in fact, we know that HR was not involved.
Is there in the record that Goutreau gave Colby the ages of the people who are up for termination?
What's established in the record, Your Honor, is that she gave him general files which contained all of the demographics, including age. There's absolutely no evidence in the record that she told him to consider age. In fact, Colby testified and she testified that they did not, that Colby made these selections by himself.
Just gave him personnel files that happened to contain the ages?
Yes, Your Honor. And in fact, Goutreau
And
is
by
the
the way,
person
that,
who...
again, I haven't read 378. Is he misrepresenting what's on page 378?
I'll see if my colleague can find 378, and then I'll be able to answer that, Your Honor. But I think it's also important to know that Goutreau is the person who does the disparate impact analysis. Thank you. And so she's the one who's actually charged with making sure that there is no disparate impact. And we know that there, in fact, was not a disparate impact in this case. In fact, we know that...
I'm not sure. That's,
Well, we know
to
that-
me, that I find the fact that, I mean, it's rare that everybody terminated is in their 50s. That's a,
Well,
that's
Your-
a s-
Your
sort of
Honor,
a,
the experts agree that there was no disparate impact for people over 40.
yeah,
And
but we're
I think it's
talking, but they
important to-
disagree about over 50, and isn't he 54 or something? So I'm just, I don't get why over 40 matters when
Because
he's,
that's the statute. And so,
I understand they're protected by the statute.
And remember
But if you're
that-
discriminating against the elderly part of that group, isn't that discrimination?
Your Honor, it's undisputed that if you look at the actual statistics that are unrebutted and undisputed, Ken Colby kept the 5 oldest people in his group, people who are 62 and
No, I can
years and
fire a
older.
black person because they're black because I ended up keeping 3 other black people?
No, Your Honor. What the issue here is whether he was acting with animus. And it's impossible to say
Right, but
that.
we're a pretext-only jurisdiction at this stage. I'm not saying that your client discriminated on the basis of age. I'm just suggesting that you have not shown that there isn't a genuine issue of material fact.
Your Honor, I think what's important is that this is because it's a disparate treatment case, the question is whether Ken Colby acted with animus. And it's impossible to say that he was discriminating against old people when he chose to keep the 5 oldest people in his group who were 62 years and older.
Why
And
is that? Why is that the case?
Because it
I mean,
shows that.
go back to the race. Let's say I fire somebody because they're black, but I still have 3 black people on my staff. Is it impossible for me to have discriminated on the basis of race?
Your Honor, we need to look at the whole record, right? And so we know that Colby was charged with doing a 22% reduction. We know that he used these 3 business factors, which were basically all about whether the person was central to R&D. We know that Adams was not central to R&D. He admits that. He worked mostly on battery quality, and so he was a logical choice for this RIF. And we know that they were longtime friends. We know that the plaintiff admitted under oath that he did not act with animus. And the plaintiff is trying to run away from that admission now, but it is clear in the record that he was asked, do you have any reason to believe that he acted
No,
with animus?
and I read
he
that.
said no.
I read that, and I think you're giving it a fair reading. But how about the cat's paw issue, which is, what I find the most troubling here is the targeting of, this group is a sort of, and also, isn't there a document that says the Andover group is old or something to that effect?
I don't believe so, Your Honor.
No, I bet you there is, but.
I thought there was
So
an
we have to
October
focus on Ken
2015
Colby.
statement that Boston needs age diversity. Stocking team with young talent would be a good idea. Is
So-
that not in the record?
So I want to get to both cat's paw to make sure I address your question, but also to talk generally about
But
the
that's the
stray
cat's
remarks.
paw. That's what I'm focused on, because I think you're going to have a very strong case at trial that Mr. Colby is buddies with this guy, is not targeting him personally. But the business has got this age diversity focus, and they're focused on this group, and there are other R&D groups that there's no focus on. It isn't, again, for summary judgment purposes, don't we have the cat's paw out here?
So, Your Honor, a couple of points on that. One is that this is not the case to adopt the cat's paw theory for the first time. The SJC has never actually adopted
Well,
that theory.
it may be the perfect case to deal with this kind of problem, which is,
I don't believe so, Your Honor, because there's no evidence that Colby was acting as the cat, right, as the dude.
well, he may be acting as the paw, that the cat is telling him, I want you need to lay people off in your group. And the big shots in wherever they are saying, that group is elderly and we want a bunch of, what are the words they keep using? Energetic, college grads, they're looking for a different group of people. Isn't this, he may be the paw and not the cat, but it's the same theory, right?
Your Honor, there's no evidence in this record that there was anyone saying we need to get rid of old people. That is just not in this record.
Yeah, but smart HR people don't talk like that. They talk in a different way. I just don't know, is age diversity legal? Is that a legal concept?
Well, Your Honor, what they were referring to with age diversity sort of falls into 4 buckets, okay? So one is succession planning, which is key to any organization. And even the plaintiff admits, well, yes, succession planning is legal. If you're going to have people move up in the organization and as people retire, you're going to retain the abilities within the organization, succession planning is essential. The second bucket is university recruiting. And so it was essential for technology purposes to work with these universities, not only to train the existing employees, but also to bring in people who had specialized skills. There's nothing pretextual or discriminatory about that.
Totally
the third
agree.
bucket is early retirement programs, which they considered, didn't actually adopt.
The problem is that they connect the points and use sort of words that we discourage, that
But Your Honor, there's no
young, energetic.
There's no evidence that this group was selected for budget cuts
But again,
because of their
on
age.
summary judgment, we don't, but there is, as Justice Wendland wrote you, some discussion about this group being old. And it's,
There's
again, this
nothing in
is
the
summary
record-
judgment.
There's nothing in the record to suggest that this group was targeted because of their age. There were reductions in other groups, nothing to connect that. And we know that Colby made these decisions for business reasons. He looked at who was essential to R&D. That's who he kept. And Your Honor, I wanted to address your question about Granado. So we know, it's undisputed, that Colby went and tried to actually save Adams' job. He went to Kabai, who was the logical person that Adams did most of his work with. He went to him twice, so not consistent with age animus, and tried to get him a new role, and unfortunately, he didn't have the budget for that. Granado was traveling out of the country at the time. When he comes back, Granado sort of raises with Colby, would it be possible to hire him back? There's nothing in that scenario, in the record, that suggests that there was anything discriminatory about that. In fact, we know that he tried to save his job.
But he doesn't want Adams to be hired for field quality. Granado wants him to be hired, and Colby decides, no, we can't do that.
Your Honor, Colby doesn't decide no. What he does is tell Granado 2 facts. He tells him that, in general, there's a practice of not rehiring people within the first 6 months after a RIF because there are issues with the severance agreements. That's just a fact. It's nothing to do with age. And he also tells him that there may be HR issues because Adams had been arrested for domestic violence, for refusing to give up a gun collection, and that may pose complications. Neither of those has anything to do with animus, and we know that Colby didn't have animus because the plaintiff admitted that. In fact, not only did he admit it in his deposition under oath, but when we posed a statement of undisputed facts at summary judgment, he admitted that fact. This is a discrimination case, and he admitted that there was no age animus. And so when you look at the full record, the fact that he was using business factors—
They say that's not what he said in the deposition.
I'm sorry, Your Honor?
They said that's not what he said in the deposition. that-
Your Honor, I invite you to look at the record because he was asked that direct question. And again, at summary judgment, we said that he admitted that there was no animus and in our statement of facts, and he said admits. It's right there in the record. He's trying to run away from that now because it's fatal for his case. But we invite the court to look directly at the record. There are many liberties that have been taken, as the dissent pointed out below. I did want to address the Reeves issue because I do think it's important for this court to reestablish the summary judgment standard in the Commonwealth.
If you don't mind.
I'm sorry?
Briefly?
Yes. So it's clear under Rule 56 and longstanding precedent of the court that the court can and must consider unrebutted evidence. And the theory that the plaintiff is arguing based on Reeves has been soundly rejected, not only by the appeals court, not in this case, but in another case called Campos, and in the First Circuit, in the District Court of Massachusetts. And because the appeals court, in our view, got that wrong, it's important for this court to reestablish that, because otherwise it's really the end of summary judgment in civil cases in the Commonwealth, and certainly in employment cases where the witnesses almost always work for the employer. Thank you, Your Honor. We'll rest on our briefs.
Thank you.